They are not actually dealing with the different things. They are not.
It is a mechanism to solve your disputes. Why the main agreement?
There is a note of the subject matter in the main program.
Now let's carry on with 6.4. On the basis of the doctrine of separability, the arbitration agreement being a separate and distinct agreement from the underlying commercial contract would survive independent of the substantive contract. The arbitration agreement would not be rendered invalid, unenforceable or non-existent, even if the substantive contract is not admissible in evidence or cannot be acted upon on account of non-payment of stamp duty. Here, Millards, two concepts, Millards. One, separability is a legal fiction. Again, I'm repeating, definite purpose. It can't go on to a stamp act. Number one. Number two, the bar applies to an instrument. The instrument contains your main contract and your arbitration agreement. It does not say this part is void, this part is bad, good, this part is bad. It is the entire instrument which has to be eschewed from consideration. The main
the agreement for arbitration, will it be an instrument? It will be. So it will be a separate instrument.
Instrument is defined.
Instrument within an instrument.
Instrument, if we see the definition of
because section 5 and 6 speaks about the duty to pay stamp duty.
Right.
When you have many instruments, and then will be paid on the duty which attracts, the agreement which attracts the highest duty.
Because I will place before your lordship, once I go to the stamp act, section 5 of the stamp act, and then basically section 3, which is the charging section, then section 5. Then there is a complete mechanism in the stamp act itself. When it is to be paid, who will pay, if he does not pay, if he is in doubt that how much is to be paid, he can give it to the collector under 30. There has to be, and then there is no time limit. 31, it can pay. If person A is responsible, person B pays 44, will apply. It's a completely defined mechanism. In case of a dispute, the collector can refer it to the Chief Revenue Authority. He can refer the matter to the Honorable High Court by making a statement of case. It's a completely different mechanism. And ultimately, what are we looking at? We are looking at the issue whether or not you have paid stamp duty. Simple. A, it can be in two ways. On the face of the document, it would be on a stamp paper. If you have paid it, because section 17 says at or before executing the instrument. That's the time that you paid. So you would have a stamp paper. If you don't have a stamp paper and you choose a section 30 mode, 30 and 31 mode, you will then have a receipt of actual payment, which is in the form of a stamp paper, that wherever you put the contract would form part of the agreement. That, sir, on the face of it, the first page, it is not stamped. I have paid stamp duty, it is here. Or the agreement itself will show on the first page. In our case, for example, 200 rupees was payable, 100 rupees plus 200 rupees stamp. This is the plan.
Banerjee's argument is that look at the object of the Arbitration Act.
Yes.
You want to have speedily, you want to attract international arbitration, you want to become an arbitration hub like Singapore. So how do you do this if you're going to be stuck at the first stage?
Because I'll answer that very simply.
Chronology of state.
Because our desire to make India an arbitration hub, this desire to project it, can it be, Millards, at the altar of saying that please don't look at the law? No, because effectively what is being said? In section 11, there is a duty to pay stamp duty. Right? It's your obligation. Under the Stamp Act, if it is chargeable, you have to pay stamp duty. Person A violates it, not paying stamp duty. Then comes to court, saying that, sir, I may be liable, I am liable to pay stamp duty, there is so and so, but you also now don't look at the bar at 35. You go and appoint an arbitrator. Please appoint the arbitrator. So you commit another error by overlooking that bar. So is this argument?
He says you're just
cannot be acted upon or is rendered unenforceable in law. David is here.
Mr. Goel, just give us the corresponding paragraph in SCC.
Uh, This is para 28.
Yeah.
Thus, according to me, the caveat has to be till it is duly stamped. An arbitration agreement would be invalid where the contract or instrument is voidable at the option of a party, such as under section 19 of the Indian Contract. We hold that since the arbitration agreement is an independent agreement between the parties and is not chargeable to payment of stamp duty, the non-payment of stamp duty on the commercial contract would not invalidate arbitration clause or render it unenforceable, since it has an independent existence of its own. Again, separability comes in.
Again, that is wrong because it is itself exigible to duty.
That's apart. Now, please have a look at text. The view taken by the court on the issue of separability of the arbitration clause, mark this, on the registration of the substantive contract ought to have been followed even with respect to stamp act. The non-payment of stamp duty on the substantive contract would not invalidate even the main contract. It's a deficiency which is curable. There's no doubt it is curable. Now, my grievance is, now look at the sentence, the view taken by the court on the issue of separability of the arbitration clause on the registration of the substantive contract. Two completely different provisions. Section 49 proviso permits you. Section 35 creates a bar. Doesn't remove it until duty is paid.
Banerjee kind of some to also argue that admissibility and inadmissibility of a document, that question may not arise at the section 11 stage. He drew parallel to a suit.
Okay.
After discovery, the admission of document.
My contention is very simple. How do you discover stamp duty is paid or not paid? Just look at the document. Look at the agreement. It will be either on a stamp paper, your first page, second page, third page, or the stamp duty, once paid, would have a certificate, endorsement. You will have stamps, e-stamps attached to it. And whenever you will file such a document, an agreement, you will at least, now that you know it requires, you will enclose those pages also. It would form part of your agreement. So is it such a difficult stage, such a difficult thing that a section 11 court would not look at it? Because what are we looking at? Now at a stage where we have to see the bar created by 35. It applies to the entire instrument. Admissibility, not to act upon. Till what? Till duty is paid. What is to be done?
But it is whether it is sufficiently stamped. It requires consideration.
Because I will come to that. For that, I will show section 29 of the stamp act. In your instrument, you have to disclose all material facts which affect the chargeability. Now, because there is a judgment of this court, you will also want to ensure. The agreement said, for the agreement to sell said possession has been delivered. And according to the concerned stamp act, it was to be stamped.
And Tuesday, that's all we get.
Mr. Banerjee, you also, if the question has to be reframed,
It has to.
do it and give it to us.
My lord, I have made one attempt, as your lordships have seen. I anticipated this problem, my lord, therefore I deleted some portion.
Well, this question will not work. Because they have proceeded on the basis of splitting the contract.
The foundation is wrong.
My lord, I have deleted that
That's
portion
why
of the.
you are going ahead with splitting. The splitting business will not be there.
Splitting business will not work with stamp duty. My lord, I had said that right at the beginning.
That's why you have a reformulation.
I have reformed. That's why I have reformed. Deeply. Only two requests, I'm not arguing, two requests. On Prem Kumar Jain, I may be permitted to file a two-page note.
Sure.
But it's not a good law and your lordship.
You have the note right now?
No, I'll file it by tomorrow.
No problem.
Second, look, I have already filed an application seeking reference. I have already argued the points. So for that also I'll file.
But we didn't hear any argument on a reference of that.
At the end of the constitution bench, your lordship asked.
That was never argued. To a larger degree. This was never argued. We are now in rejoinder.
No, I'm sorry. I'll point out. In fact, Lord, the reference is needed. Lord, I have already argued the difference.
Now, it can't be now after Dr. Singhvi is in a rejoinder.
No, allow me, Lord, 2 minutes.
The reference has to be argued at the outset. We are now where Dr. Singhvi is virtually, we would have finished yesterday.
Lord, your lordships would recall.
We were also flagging in energy at the end of the day and we thought we must give a fresh.
No, certainly. Your lordships would recall, when I filed the application and Dr. Singhvi objected, my lord said that he can always argue during his submissions. My lord, the Chief Justice were pleased to say. Lord, the reference essentially is on the ground that the contours of federalism between union and union territory requires relook other than, my lord. So, my lord, I'm not, my lord, repeating anything. It is covered in my argument. I'll just put a two-page note.
That is not.
No, your lordships in fact said that let it not be separately argued. It would be covered in his argument.
I mean, we would have looked at the matter very differently. I mean, if there was the issue of reference was never been argued. I mean, we are now, your argument, your side is.
I understood your lordship saying that instead of filing an application.
We'll consider. Dr. Singhvi?
Yes. No, his lordship should remember, there's two things. I mean, I would want to eat.
Only, my lord, before it.
I don't.
But I would honestly urge your lord, my lord, the Chief Justice. When I mentioned that allow me to circulate, my lord said that you can always cover it in your arguments.
No.
But it was not covered in the argument. That's the point.
All points are covered without using the word reference.
With great respect, Malas, this matter came before the division bench which referred it to your lordships about 10 times. I think Justice Kohli was part of that bench. 10 times over 1 year or 6 months. It was in fact listed for hearing, etc. Went to 3 judges, Justice Suryakant was there. Not at any time was a reference mentioned. No application was filed. Matter is listed by our lords for 10th. Just before that, a few weeks before that, it is raised. It is not told to your lordship that the prayer is identical to a review filed. This your lordship should know. 90006 of 22 by my learned friend. 4.5 years, 3.5 years after the 2018 Constitution bench. A review of that. This is nothing but the same thing. He files it, on May of 21, 3.5 years later. He, is saying that that judgment should be reviewed. Why? Because it is contrary to NDMC. That's the short point. Identical prayer in a review filed 3.5 years after the Constitution bench is repeated a few weeks before this bench is to convene. With great respect, the lordship in the Constitution bench doesn't allow these things. What is the review? What is the reference, fellows? Reference is simply one sentence actually, boils down to. There is a NDMC. NDMC,
there are
9 judges.
Points which I have
Sorry.
but I don't.
And it should be referred. Your lordship has dealt with NDMC, good, bad or indifferent, 10 times in the Constitution bench. What your lordship will do with it is your lordship prerogative there. You already dealt with NDMC. For that reason, it should be referred to now 9 judges or maybe 11. Well, with respect, this will be hugely dilatory. Your lordship has spent all the time. Today, we have gone into the Constitution bench, we've gone into everything.
Lord, it can be anything but dilatory, my lord. We are dealing with the capital of the nation, my lord, and therefore, whether it is done today or tomorrow, my lord, that hardly makes any difference. My learned friend may be in a tremendous hurry to do certain things, my lord, but we are more on the future course of action, my lord. We may not be remembered in history for having handed over, my lord, capital to a complete anarchy.
I don't see
That's, my lord, my argument, and I have made those submissions. I'll just, Lord, put it 2-page note.
It is entire 90
pages
and 54 pages, total of 140-50 pages. No reasons given for reference. Not asked. In his entire submission. Well, this is with respect. We can't repeat this capital, like a mantra every time. Of course, it's the capital. And it's a capital with a legislature with representative democracy. Their argument is the merit, nothing to do with the reference to 7 judges. Today, your lordships, having dealt with the entire 2018, so many paras, are suddenly at the end of my rejoinder will ask for reference. That would be very unprecedented for a constitutional.
But I repeated that. I have covered the issues in my submissions. If your lordship permits, I'll place a 2-page.
May I start?
Yeah.
But can I place a 2-page note on it? That's all.
I am objecting. This will go on and on endlessly. It will be made a ground subsequently for a 9-judge bench reference. With greatest respect.
No difficulty that you can certainly give your note because that's a question of law about.
Understood. I leave it at that. It's ultimately my lord's entire prerogative. Your lordships may only record that I reiterated your lordships have not considered. That's all. It should not be argued that it was argued and rejected. That's all.
It should not be an ambush procedure, Wallace. And your lordship.
So I'm saying something factual.
This issue can.
Yes, it's a reasonable request that your lordship may record.
Yes.
Say that we are not going in.
Now, Wallace, your lordship had reached para 3, and I'll speed along and I'll finish within my 1 hour. Wallace.
Yesterday's.
What I've done is, I have given you a short 2-page additional rejoinder note. Lordship may open both yesterday's and today's, and that will be about all.
We hope that tomorrow there may not be any another. I have
That
Never give a lawyer one overnight, but me also included.
with greatest respect to all of you, just speaking from myself, I have never seen submission, additional submission. Every day in the night we are taken by surprise. In the morning we are taken by surprise.
this is only a quotation mostly.
No, it's okay, but
97, Wallace.
Anyway,
97
please consider it.
Now, Wallace, kindly open the main submission which your lordship has got, which your lordship opened yesterday.
Yes.
Now, Wallace, allocation of, this is where your lordship started, ended yesterday. Allocation of all India civil servants in respect of Agmod Kader is done by the Joint Kader Authority and not Ministry of Home Affairs as stated by the Learned Solicitor General. Now, Wallace, here, your lordship will straight away turn to section 3 of the Act, Rule 4 thereafter, and the notification. These 3 documents. In the sequence of 3I, the Joint Kader Authority is established under Rule 4 of the All India Rules, which are statutory rules framed under 3.1. The authority is a committee comprising representatives of each of the government of the states constituting the Joint Kader. The Agmod Kader has been established under